You obviously have had time to reflect on some of the issues we discussed. Are you ready to say something?
Indeed, Chair. Thank you so much. Chair, we ended yesterday on the question broadly of relevance, and I'd like to propose addressing that in three parts. The first
Well, let me tell you what my thinking was at some stage last evening about the matter.
Thank you, Chair.
We have to keep on going back to the basic proposition that this is not a court of law. We have to keep on reminding ourselves.
Indeed.
And that is all of us, both the lawyers and myself, because we are all too used to a court of law. And our experience in courts of law is, to a very large extent, part of our life. But of course, once we remind ourselves that this is not a court of law, we have got to try and think in the context of a forum that is not a court of law. And to a certain extent, we have also to think of terminology that is not a court of law terminology, because sometimes we may be using court of law terminology because that's what we work with all the time. But actually, maybe we should be considering different terminology depending on exactly what we mean and what we want to achieve. Now, this is a commission of inquiry. It has got a team of investigators and a team of lawyers. The contemplation is that the investigators would investigate and bring the product of their investigation to the Commission's legal team. And the Commission's legal team would look at that product and advise if it's good enough to be presented to a hearing, and if it needs to be worked on further, they give that advice. At a certain stage, they might be happy to present it to the hearing. Now, when you investigate, an investigator may go to destination A for purposes of investigating. And at that destination, he or she might come across certain real evidence. And might need to examine that real evidence before he or she may say whether it's really going to be useful for a hearing or to be taken to the legal team and so on. Or he or she might need to go and interview certain other people before he or she takes a view whether it's something worth handing over to the legal team. So, for purposes of investigation, if there's still going to be investigation, it might be difficult to say whether something is relevant. Maybe it might be enough if it's potentially relevant. And whether it is in fact relevant might be established after some further investigation or some examination, some analysis. So it may well be that the component of the HDDH, whether one or two or both, it may well be that the component thereof that has not been analyzed need not be shown to be relevant at this stage, and that it should be enough if one takes the view that it could be potentially relevant or something like that. And maybe to that extent, one should not, maybe I should not ask for more than simply showing that it could potentially be relevant. So that is the one part. But when I read the affidavit again this morning, it seemed to me that the real reason or purpose of the application, at least then that one could gather from the affidavit, seemed to be that it's believed that there must be an admission of this evidence first before, or in order to enable investigators to analyze the data and do their investigation further. And at a certain stage, the evidence would come back after they've done that. Now, ordinarily, in a court of law situation, things would happen the other way around.
Correct.
The examination of evidence and or real evidence or objects would be done first. And when the court is asked to admit that evidence, it would be because that part has been done. It's as far as the particular party who wants that piece of evidence to be admitted is concerned, they've done their job. And when it's admitted, it's in the court and so on. So, but here it seems to me that what is envisaged is something that is different. An admission is sought and then investigation or analysis later. And it's not clear from the affidavit why that has to be so. But as I said yesterday, the hard drives or the forensic images thereof of HDDA are under the control of the Commission. And as far as I'm concerned, I know nothing that should preclude the investigators from doing their job in relation to that piece of evidence. And at a certain stage, we have certain evidence from Mr. Brian Curran from yesterday about what you call, I think, chain of custody. It's not everything. There are still other parts that are dealt with, as I understand, in an affidavit that is to be handed up to me. And I suspect that the evidence of the whistleblowers, or at least one of them, in relation to how originally HDDA came to his possession, is something that will be dealt with at some stage when those whistleblowers are able to give evidence either in an open hearing or in camera. My suspicion is that at that stage that will give a complete picture about the chain of custody. Now, I don't, obviously one would have preferred a situation where the chain of custody would be completed now. But I don't have a problem with the fact that it's not completed now. It will be addressed in due course. I don't see anything that really precludes either the legal team or the investigators to do what they need to do using this evidence to advance the work of the commission. So that's where I am.
Indeed.
And it may well be that part of excuse me, part of the challenge that we all face is what I said earlier on. We are used to a court of law situation, court of law terminology, and court of law procedures. I mean, there is no requirement that the chairperson of a commission of inquiry must always be a judge. There is no requirement that he or she must always be a lawyer. So that this commission may well have been chaired by somebody other than a judge or a lawyer. Of course, a judge and a lawyer comes with certain advantages, but as I say, maybe sometimes there are disadvantages. So I don't know whether, for example, if it was somebody who was not a lawyer, you would bring an application for admission, for an admission.
Indeed.
So I'm sharing these thoughts with you so that you understand some of the thoughts that I had, because I also reflected on the application. So one, as far as I'm concerned, the evidence is within the control of the commission. Two, the evidence appears to be very important. Three, there is no reason, as far as I can see, you might give me one, I see no reason why the investigators shouldn't do their work using this information, analyze the data and move on with the investigation, and at the right time the matter, they would obviously come back to the legal team and say, this is how far we've gone, this is what appears to be the case, and the legal team would at the right time, bring the evidence or aspects of it back to a hearing. And then it may well be that to the extent that one may need to talk about admission of evidence even in a forum that is not a court of law, to the extent that one may talk about that kind of terminology, it may well be that that should stand over until I've had all the relevant to authenticity and other things, and I would decide, admissibility later. But in the meantime, I see no reason, for example, if a witness was giving evidence here and the legal team being aware of certain emails implicating that person, I see no reason why, for example, that witness couldn't be asked about such an email, for example. And obviously, any witness who has an interest in relation to or is implicated by the emails, who wants to challenge the authenticity of the emails, should be allowed to do so. At a certain stage, I would make a decision, and it might not be necessary to make it at a certain time. I might wish to make it right at the end. But subject to what anybody might say, I don't see why there should be any problem with the legal team and investigators pursuing their work to advance the work of the Commission, even in relation to using that data.
Thank you, Chair. Chair, we greatly appreciate your guidance on these aspects. If I may pick up the point about terminology, because I think it is an important one, and you've already signaled the need for everyone concerned to remain on the right side of the distinction between courts and inquiries. And our reflection overnight as a legal team indicated to us that the language that was selected for the notice of motion, for precisely the reasons that you've identified, may not have been apposite. The notice of motion talks about admitting the data, and the challenge with that is that it holds a whole host of connotations from a judicial forum that brings in questions of rules of evidence on admissibility that are, quite frankly, inappropriate here, because that is not the standard or the test here. And Chair, it was with that reflection that we went back to the rules of this Commission, which we submit in fact provide the guidance. 6.1 of the rules does not talk about admitting evidence. It talks, and we think with wisdom, with respect, about receiving evidence. Receiving doesn't have any of the loaded connotations that admission does. Admission takes us back into a judicial setting. We should resist that as a Commission of Inquiry. That is our submission. And so the first proposal that we'd like to make in relation to the application is that if we go to the notice of motion, we submit it is actually appropriate for the notice of motion to read in paragraphs 1 and 2, not that what is sought is a ruling admitting the data, but receiving the data, because that tracks the rule 6.1, and it makes clear what the test was that was then applied. Because 6.1 says simply that the Commission, and I'm quoting now, may receive any evidence that is relevant to its mandate. And I'd like to pause on mandate, because it's again important when we're mindful of this distinction to understand that the mandate of a Commission of Inquiry is to investigate matters. It is not to determine legal rights. It is not to determine guilt or innocence. It is simply to investigate, and upon completion of the investigation, to make recommendations. So that again gives us an insight as to what receiving evidence means. It doesn't mean receive evidence in order to determine rights, which is actually what admission in a judicial context will carry as its significance. It simply means receive evidence that is relevant to the investigation that the Commission is doing, and which will result in the end in its recommendations. So, Chair, our first proposal to you today would be to remove the language of admission. It is, with hindsight, unhelpful. It takes us back to the judicial setting that we must studiously avoid venturing to, and it clarifies what is being sought. It is simply a receipt by this Commission of that information to progress its investigations. Chair, I'd like to link that to the guidance that at least one of the cases that was handed up to you yesterday provides on this question. It's the case of Ross v. Costigan. That was in the bundle of authorities. And Chair, the reason why we give further attention to this authority is because it actually provides very useful guidance in addition to what I addressed yesterday on this question of where can a Commission probe and what evidence may it receive in the course of its investigations. Before I take you to the relevant paragraphs, I should just give a bit of background about the case. This was a case involving a Commission of Inquiry in Australia into the shipbuilding and ship repairing unions within Victoria and New South Wales. A commission was established to determine whether any officer or member of those unions had been engaged in illegal activities related to shipping. And so the Commission began its work, and in the course of its work, counsel for the submission had discovered that there was a possibility of involvement by employees of the various companies in tax minimization schemes. And on its face, it looked as though those tax minimization schemes were beyond the remit and mandate of the Commission. But counsel for the Commission sought leave from the Commissioner to pursue that line of inquiry and indeed to summon witnesses that would be able to give further information on the question of the involvement in this tax minimization scheme, which may indicate engagement in unlawful activities. And those who were going to be summoned and implicated by that line of inquiry ran to court to try and stop the Commission in its tracks on the grounds that this would be beyond its mandate. And Chair, in dealing with that challenge, if you go to paginated page 17 of the bundle, the authorities bundle, you will see there on the left-hand side of the page, on the reported page 326, what the court is recording there is the reaction of the Commissioner when this issue was first raised with him. And I'd like us to look at that and then look later at what the court made of the Commissioner's findings, because the court ultimately upholds the Commissioner's determination that the leave should be granted, the witnesses should be summoned, and the investigation should proceed. From about the fourth line down on that page, this is what the Commissioner recorded in his reasons. He said, in an inquiry of this kind, it is impossible to lay down in advance the limits of investigation. And yet this is what the submission made to me would require me to do. Is not one view of the evidence that the payment made to a painter and docker company director came to him at least indirectly from a taxpayer? At the very least, am I not bound to inquire into this matter? If the evidence should disclose that a taxpayer either knew or ought to have known that his tax was being minimized by the use of painters and dockers as company directors, am I not obliged to inquire as to whether this falls within the concept of the use of the union for illegal activities? That's a quote from the terms of reference. I am not making any findings on these matters at this stage, and will not until the evidence is complete and submissions have been advanced on that evidence by those who wish to make them. But it is not possible to limit my inquiries into those areas by producing a conclusion midway through those inquiries. Chair, that finding on the part of the Commission is ultimately upheld by the court. And the test that the court sets is, in our submission, a useful one for your consideration of this application. And Chair, that appears on paginated page 21. It is on the reported page 335, which is on the right-hand side of the page, and against line 18 it begins. This is where the court, having upheld the Commissioner's determination that the investigation should proceed, really articulates the essence of the question. There the court says, if there is a real, as distinct from a fanciful possibility, that a line of questioning may provide information directly or even indirectly relevant to the matters which the Commission is required to investigate under its letters patent, such a line of questioning should, in my opinion, be treated as relevant to the inquiry. Chair, we seek to emphasize there a few things. The test is set at the level of possibility, which is even lower than probability. I seem to have turned off my microphone. I will address you in due course about the probabilities in this evidence.
That seems to either be similar or the same or close to potentially relevant
Indeed.
that I mentioned a while ago.
Indeed, Chair. The investigation should not be stopped at any point unless, as we read the standard here, it would be fanciful to proceed down that line of inquiry. If it is not fanciful, if it is possibly relevant or potentially relevant, either directly or indirectly, says the case, well then it should be pursued. So, Chair, we submit that with that fairly minor adjustment to the notice of motion, we actually achieve quite a lot, because we seek to clarify before you today that we are not seeking in this application admission of the data in the formal sense that that word has in a judicial context. We are seeking simply its receipt, because from what is set out in the affidavit, and I will take you to just the highlights of it, together with Mr. Curran's evidence, it is quite clearly not fanciful that this is a line of investigation that must be pursued.
Yeah, no, you won't need to address me on whether it's fanciful
thank you.
or not. Yeah.
Thank you, Chair. Chair, let me then just move to the question of potentially relevant, because it may be useful to use that as the placeholder for what this Commission is tasked with doing in the face of this application. Chair, we submit that there are at least two primary indicators of the potential relevance of the HDDH data which we seek to have received by this Commission. The first is that it is data that comes from a hard drive from Sahara computers. That on its face, Chair, places it squarely within the line of sight of the mandate of this Commission. And we say that because Sahara Computers is a Gupta-owned company, or was at least. It is one of the companies that the four major banking institutions of this country severed ties with at the beginning of 2016. It is also the company that, in the evidence of Ms. Mentor, she was taken to in advance of the meeting with the former president at the Saxonwold residence of the Guptas. Sahara Computers is squarely within the mandate of the terms of reference of this Commission. And the Commission has within its possession a hard drive from that company.
Yeah, no, I think certainly no order ought to be made that should preclude the investigators from saying, let's have a look. Yeah, so I think the potentially relevant is quite clear.
It's manifest, Chair, we would submit.
It seems to me that with the amendment that you propose of not using the terminology of admission and using receiving, there should be no problem with subject to certain amendments, such as in one. I don't think we need to mention the name of the Commission, because it's the Commission
Indeed.
making the decision.
Indeed.
So such as that, 1 and 2, there should not be a problem. With regard to 3, I don't know whether a rule nisi is the best form. And of course, as I just said a few minutes ago, what we know best is what happens in a court of law.
Indeed, Chair.
So from time to time we have to go back to what happens there, but we must immediately remember to get out.
Indeed, indeed, and quickly, I would
because
submit.
if we stay there too long, we'll make mistakes.
Indeed.
I mean, in a trial, all you would have would be a judge or magistrate saying, exhibit so-and-so is provisionally admitted. I'll make a final decision later. It may well be that the rule is the right form. I'm just raising it.
Yes.
But I think the basic principle is that as long as whoever may be affected has an opportunity to be heard before a final decision is made. But it may also be that to the extent that we no longer use the terminology of admission and simply saying receipt, it may well be that that doesn't affect anybody's rights or interests. I'm not sure. But I'm quite happy to say whoever wishes to be heard at some stage before a final decision is made as to whether to admit or not, will be heard.
Indeed, Chair. Chair, if I may address that in two parts. You probed earlier with me the question of the purpose behind this application. And it is important in that context to make one submission that is related to this latest engagement. This commission is a public inquiry. It was therefore appropriate, we submit, and in the interests of the transparency of the processes of this commission, that when it was possible for this commission to make known to the public that its investigators and legal team had possession of this data, and linked with that the extreme lengths that the Commission went to in order to secure the integrity of the data and to have it recovered by an international expert, that those facts be made known to the public, because there may well be people who are implicated by that information. And so part of the purpose of bringing this now and not later was in the interests of that transparency, to tell the public this is what we have, this is what will be analyzed and which will forge our investigations forward. And so in that context, it may well be sufficient merely that the application has been brought, and that if the ruling is receipt of the evidence, then in due course notice in a sense has been given publicly to all those who may wish to contend that something is inauthentic or some particular piece of that information is not relevant. So in response directly to your question about paragraph 3, we submit it may not be necessary. This application has taken care of the general public notice that this information will be worked on and will be presented in due course where it is appropriate and pertinent to the matters of investigation, either in the leading of evidence or in the cross-examination of witnesses. And the rules of this commission, of course, permit applications to be made on 7 days' notice. And so an appropriate person, if that person wishes to make submissions in relation to the receipt of this evidence, could certainly do so. This will serve as the public notice for that purpose.
And would it be fine to even the receipt to make it provisional?
Chair?
You know, in terms of admission, we're talking of provisional because there would be a final decision later. Of course, admission and receipt are different things, but it may be that if one says provisional, it just sends the message that anyone who even may be saying no, it should not be received, no door is closed. They can come and make whatever argument, and final decisions will be taken later on. It may or may not be that it's necessary to say it's provisional. I don't know
Chair,
what you say.
we submit it's not necessary to say that it's provisional. And the reason for that is really the guidance that we can again seek from the Australian case. Investigations move, commissions of inquiry move along lines of pursuit. And it is not appropriate at any point to make a definitive finding as to what weight will be given to or what importance will be attached to a particular piece of evidence. What will happen now if this ruling is granted is that the Commission is receiving this evidence. And it is receiving
Factually received.
Indeed. Factually so, and so that the processes of investigation can be advanced through analysis and later presentation. So we would submit, confining it to a provisional status would not be appropriate.
I guess that it's just what we keep on doing, because when we were talking about admission, it was necessary to talk about provisional.
Yes, indeed. But we're not there.
We're now moving, and of course, we are bound to think how much of what we had in mind in relation to admission we must retain when we say receipt. You know.
Chair, our
so
submission
maybe to the extent that receipt is nothing more than factually received, that fact is not going to change.
Indeed.
And that order would not be precluding anybody at any stage to say, I'm not talking about receipt, I'm now talking about admission. It should not be admitted. That remains open.
It does, Chair.
Yes.
And that is precisely why we thought, albeit a small change, it's an important change to the manner in which the ruling would read. We don't believe it needs to be circumscribed by provisional, for all the reasons that you've given, Chair, with respect, and also to resist that movement back to the judicial frame. It's not appropriate. This Commission can receive any evidence relevant to its mandate. This data is clearly that, and so the ruling should be given. And they will be given, we submit, on notice to all who may in due course want to challenge a piece of that information.
I am ready to is it make an order? Seeing that we make some ruling, well, in the end, maybe whatever you call it, it would be an order.
Indeed,
or ruling.
The ruling.
I'm ready to do so, but I would probably effect some more amendments on your notice of motion.
Indeed, Chair.
But ones that I don't think you would have any problem with.
Chair, that's ideal. If I may just mention the in-camera affidavit. We do still need to present that to you. I wonder if it is maybe an opportune time to take an adjournment now so that that can be done.
Okay, let's do that. Well, maybe we may as well use this time for tea.
Yes,
for the tea break. And then when we come back, we finalize.
Thank you, Chair. We're in your hands.
It's 11:15. That affidavit, of course, I don't have an idea how long it is or how long I might.
It's very short, thankfully.
Okay, so we can do within 15 minutes. I should be able to. Okay, all right. Or maybe just to be on the safe side, we say we will resume at 11:05.
Certainly, Chair.
Okay, we adjourn. I have read the affidavit. Is there anything more that either Mr. Pretorius or Ms. Hofmeyer wants to say?
Those are our submissions,
Okay.
and we kindly request that you take them into account in fashioning the order that you wish to, with those amendments that we have submitted are appropriate.
Okay. Thank you.
Thank you, Chair.
Thank you. Having read the papers and heard argument, and having also read an affidavit given to me in chambers in confidence in support of the application, I make the following order stroke ruling. 1, I'm going to leave out admitting at the beginning and put it a little later.
Yes.
1, the data referred to as, quote, the HDD H data, close quotes, on a hard drive, open brackets, with model number ST500DM009 and serial number Z9ADLVFT, close brackets, referred to as quotes HDD H, close quotes, you had is, I think, should it not be
Is received by.
Is it is, data is, or data
Yes.
What is the correct English?
The data is received.
Is received. Okay, all right. Is received as evidence before this commission. That is 1. You got it right, or must I repeat? Have you got it?
I have it, Chair.
Okay, I'll just say again. The data referred to as, quote, the HDDH data, close quote, on a hard drive, open brackets, with model number ST500DM009 and serial number Z9ADLVFT, close brackets, referred to as, open quotes, HDDH, close quotes, is received as evidence before this commission. 2, the data referred to as the, open quotes, HDDH1 data, close quotes, and open quotes, HDDH2 data, close quotes, which has been forensically imaged from HDDH onto 2 further hard drives, referred to as, open quotes, HDDH1, close quotes, open brackets, with model number WD10EZEX-60WN4A0 and serial number WCC6Y0RVNTJ, close brackets, and open brackets, HDD H2, close, open quotes before HDD H2, close quotes, open brackets, with model number WD10EZEX-60WN4A0 or 0 and serial number WCC6Y6HRFZHX, close brackets, as is received as evidence before this commission. 3.
Chair, may I interrupt?
Yes. Yeah.
In the serial number in the last bracket,
Yes.
you mentioned Z instead of 7 as the third last.
Oh, okay. Let me correct that.
Item.
In the order or ruling under 2, the serial number is the following: WCC 6 Y 6 H R F 7 H X close brackets. Okay. And then the original 3 is not pursued, so the new 3 will be the old 4, but it will read as follows. Notwithstanding the rulings stroke orders in paragraphs 1 and 2 above, comma, nobody outside of the Commission shall have access to HDDH data, to the HDDH data, comma, HDDH1 data, and HDDH2 data until it is presented by the legal team of the Commission at a public hearing of the Commission. I think I should add 4 to say, and I'm going to formulate it, and you can say if you would like to make submissions about whether we should have it or not.
As you please, Chair.
4, should any specific person or party wish to have access to HDDH data, comma, HDDH1 data, and HDDH2 data before the time specified in 3 above, comma, the leave of this commission will be required.
May be sought.
Will be, or such person must first obtain the leave of this commission. I think this is just to cater for maybe specific individuals who prior to that might feel that they need to, maybe somebody who, if there is any reason, just to leave it open. What is your, what's your attitude?
It's appropriate with respect, Chair. May I suggest the wording should read, should any person or party wish to have access to data, leave may be sought from the Commission. Yes.
Okay, 4 will then read, should any party wish to have access to HDDH data, comma, HDDH1 data and HDDH2 data, comma, leave must be sought from the Commission.
Well, prior to the date mentioned in 3, leave may be sought from the Commission.
Leave, okay, let me formulate it finally. Should any, that is 4 now, should any party wish to have access to HDDH data, comma, HDDH data, HDDH1 data, and DDH2 data at any time prior to the time indicated in paragraph 3 above, such party shall first seek the leave of this commission. Okay.
Appropriate. Thank you, Chair.
Thank you. That is the ruling or order in the application. I guess that at this stage, I don't know if you wish to say anything about next week.
Well, for present purposes, although this is subject to change if witnesses are able to come earlier than originally planned, but what is certain is that on the 3rd of October, there will be evidence from Minister Nene.
Okay, we will then adjourn on the basis that unless notification to the contrary is made or given publicly, the Commission will resume on the 3rd of October to then hear the evidence of Minister Nene. But should circumstances arise which require the Commission to sit earlier, the public will be informed.
Thank you, Chair.
We adjourn.